In today's video, we got the 911 calls, the text messages that night of the incident, a fair explanation on why they're doing what they're doing to get the DP thrown off the case, plus the big thing I don't see a lot of people talking about. All that being said, everything's alleged. Welcome to the point. Let's get to it.
Newly released text messages in the Bryan Kohberger case in Iowa. He's, of course, accused in this 4 University of Idaho students. This happened back in November of 2022. And the court has now released or unsealed some of the chilling words of those surviving roommates the night of the...
And I will go on and say, for the longest time, I have personally said on this channel, and I know it's not a popular opinion for people who make videos like this, but I like Judge Hippler. I feel like the rulings he has made has been within the law. Like it or not like it, the law is the law. If the law needs to be changed, it needs to be changed, and the attorneys and representatives of that state need to do what they need to do to fix those laws. But this is a big step towards transparency. Transparency is what's lacking in this particular story. And not everything coming out is heavily favoring the state. There is some stuff that favors the state, but there's also some stuff that favors the defense.
Joining us now, Court TV legal correspondent Kelly Craft. Kelly, fill us in. This is every day it seems that we're getting more and more out of this case.
Yeah, we sure are, Ted. Good afternoon to you and Julia. Bombshell evidence coming out in this case. This is for the first time we are seeing transcripts of these texts, and it's really giving us a true feeling of the real horrifying event that was taking place that night.
Yes, it's the first time we're seeing these transcripts and these text messages, but a lot of people are forgetting this is not the first time this has came up. In fact, since just about the beginning, I've been saying there's no way these roommates slept through this. There's no way this probable cause affidavit is accurate. And individuals are saying I'm wrong, I'm a conspiracy theorist, I don't know what I'm talking about, but here we go. In this video right here, I had raised the point that even if they weren't aware, they would have heard something in the home given how that home was built. And in this video right here, I had raised the point that even if they didn't hear anything the night of the incident, they would have certainly smelled something. And then Howard Blum came out and said both Dylan and Bethany were awake, they were aware, they were texting each other. In fact, Dylan ran into Bethany's room. Everybody said this guy was wrong. Everybody said this guy was off his rocker, and he didn't know what he was talking about. He was just trying to sell books. Now, like it or dislike it, it doesn't change the fact that he had validated a lot of what we had said for those of us who have concern about the accuracy within the probable cause affidavit. And with these unsealed records, we are proven correct. We all said there's no way they didn't know this was going on. We all said there's no way they weren't aware that there was an attacker in the home. And we also said it makes no sense why they didn't call 911 earlier, and it makes no sense why they told the 911 operator that someone was unconscious.
The night Maddie Mogan, Kaylee Goncalves, Zana Kernodle, and Ethan Chapin were... The 2 surviving roommates, Dylan Mortensen and Bethany Funke, they start messaging one another about not being able to reach their other roommates. And then they start panicking quickly. Let's go ahead and take a look at some of those text messages. We've put them up on the screen for you. You can see that they are expressing fear, saying no one is answering. I'm really confused. And what's going on? So you can take a look at those messages. Somebody is telling each other, they're saying, run, come down here. And then 6 hours later, Dylan tries to reach Kaylee as well as Maddie. So you're taking a look at some of the other text messages there that they were exchanging. Now, we did get a glimpse of these yesterday because this is when they were first posted.
So why didn't nobody call 911? I've said in previous videos this will be a problem for the state, and it will certainly be a problem for the state after hearing these text messages. I know individuals are saying, well, she was in shock, she didn't understand what was going on. She clearly understood enough to reach out to Bethany and talk about how freaked out she was. She saw an individual in a black mask. She heard noises. And how can she be in a frozen shock phase when she is exchanging text messages? That just doesn't make sense. It is now and will continue to be a problem for the state in terms of her being a credible witness. They should have had sense enough to understand there was something going on and they needed to call 911. Now, one theory floating around online right now is they didn't call 911 because there were party favors being used that night and they didn't want to call the police and risk getting themselves in trouble. And if that's the case, that's not a good excuse. There is a real possible scenario there where if they would have called 911 as soon as they were aware something is happening, maybe at least one of these individuals would have survived. I know Kathy Mabbitt said what she said, and she said when they passed quickly because of the violence of this attack. But in cases like this, timing is everything, and the timing certainly could have been handled better by both Dylan and Bethany, in my own unprofessional opinion.
To the docket, although there's been talk about them over the last several months. So terrifying
Years.
For the students that were in there, and this court filing in general really sheds light on the time frame, which is so important for prosecutors in a case like this, to get that timeline established. Ted and Julia?
And it does establish the timeline a little better. We know a little after 4, there was a lot of stuff going on. Dylan and Bethany were texting each other, talking about what was happening in the home. I do not believe these are all the text messages between those two individuals. I think we're looking at a redacted copy. I think there's way more that was possibly said that we just don't know about. But in terms of the time of the incident, this does back up the state's case, saying around this particular time, a little bit after 4, something went on in the home. And then the suspect did what they did and they left the home. This does back that up. It will be the defense's job to disprove what the state is saying. I know there's something floating around online about a 7-minute delay in surveillance, and that does help the defense. And I know that Dylan doesn't identify Bryan in this particular text message exchange, which also helps the defense. But it's a circumstantial case. And in terms of circumstantial evidence, this does back up the state's theory to a degree as far as the timeline goes.
It really is, Kelly, and that's terrifying, just to know what was happening inside of that room. I think I was shocked that it took so many hours before they even realized that their friends were...
That makes no sense.
To get there, they only responded just for Xana because that was the first friend that they were realizing was not responding, and they thought maybe she was unconscious. What can you tell us from this court filing? What else are we learning now that this is being unsealed?
So we're also seeing a newly revealed transcript of the 911 call made the morning. This is 7 hours after the... Let's go ahead and take a look at part of that.
And a lot of people have broke down line by line both this text message exchange between Dylan and Bethany and this 911 call. So we're not going to do that on this video, but I do have some concerns here. Why are they treating this as an unresponsive person? If this crime was so brutal and so horrific, why were these people on there saying, well, she's unconscious? Why are they treating this like an unconscious individual? You should have known. You should have looked at the area around Xana and said, yeah, she's not breathing. She's no longer with us. None of that lines up. And none of that makes any sense. It almost to a degree reminds me of the Ellen Greenberg 911 call. Her fiance comes into the apartment and calls 911, says his fiance's not breathing. The 911 operator says, hey, we'll start chest compressions. And then the fiance's like, oh, well, there's a knife sticking out of her chest. Oh. I mean, seriously? Are you kidding me? You can't tell that something's gone on here? That 911 call makes about as much sense as this one. I understand that there may be confusion, but to simply say and treat this as if you can walk into this room and say, yeah, she's unconscious, she passed out, while not knowing that there was a brutal crime committed just doesn't make sense. There is a part of me that wants to say maybe this was coached. But there's also another part of me that says there has to be a better explanation to why they acted the way they acted. Passing the phone around. Everybody speaking on top of each other. It just doesn't make sense. And I also think this might be the moment that explains the latent footprint. Because you had all these individuals in the home contaminating the crime scene. Somebody stepped in something and tried to clean it up. That's just what I'm thinking right now. That's just my initial guess and speculation. And if they did try to clean up certain areas of the crime scene, knowing that they made a mistake, what does this do in terms of the state's case? Because at this moment, the crime scene's now been altered and contaminated, and it's a problem. And it's a problem for the state.
We have this transcript of it. So you can see that it says one of our roommates passed out. That's what they're thinking, that somebody has passed out. And she was drunk last night. She's not waking up. And they saw some man in their house last night. Yeah, at one point you hear the 911 caller, the 911 operator saying to them, stop passing around the phone because there's other people that are getting on the phone call to explain what's taking place. And they're asking eventually, talking about law enforcement. And so that's why the prosecutors say this is also so important, because they're not just calling for medical help. They're letting authorities know that there is something really off going on inside that residence.
Mm-hmm. Yeah, it's set of events.
No, that call
the
made no
time
sense.
it took,
Somebody's
and then the
not
fact that they
waking
were
up.
all
Give me a
They
break.
didn't know what to do. They were obviously shocked, passing that phone around with the 911. What about the families? Every day they're hearing more, and I know it's been a very difficult road, obviously, for them.
Oh, certainly, Ted. And they always are posting comments to the latest court filings on Facebook. So the family of Kaylee Goncalves, they put out a statement. This was on Facebook after these texts were released. Why don't we go ahead and take a look at that? So reading some of the transcripts, documents that have recently been released has been essentially hard on all of us. We need this to be over. God help us all. So just new developments there in this case, and the statement from the family, as well as prosecutors are just working to get their case together because it's going to be a big one.
And I know the Goncalves family has become incredibly polarizing in this story. Some of it's their fault, some of it isn't. And I don't always agree with 100% of what they say. And I don't think we have to 100% agree with anybody and everybody in this story. But he was on News Nation and he made a couple of statements I'm going to 100% agree with. Number one, the state didn't reach out to them and say this stuff was coming out. And honestly, that's poor taste on the state's part. There are victims advocates paid by the taxpayer in that state to do this type of thing for the family members of the victims. They should have reached out to that family or Shannon Gray and said, hey, this is going to happen. Go on and explain it to them. We're doing what we can, but I don't want them to find out about this on the news, which is exactly what they did. And Steve also made another statement I 100% agree with, and I think a lot of y'all will agree with it as well. Why do they keep these sealed so long? Why didn't they release this earlier? Why is there such a lack of transparency within this particular story? There was nothing within these 911 calls or text messages that we saw that really points a finger at anybody. There was no reason to keep this stuff sealed. It just doesn't make sense. And the justice system works best when it works in transparency. That's just my take on it.
Kelly Craft, thank you. Dwayne Cates is with us. He's a defense attorney in Phoenix, Arizona. Dwayne, the defense wants these text messages out. Here. They're motioning for the court to not allow them in, saying that they are hearsay and that the jury doesn't need to hear it. The prosecution obviously wants them in, not only for the fear factor, but
come in
also
and it
to
should
establish
come
a
in.
timeline. What's your take in terms of this defense motion to exclude these text messages between the surviving roommates?
Well, it's tough to get them excluded because 911 calls are generally exceptions to the hearsay rule in that they're excited utterances. And so they generally will come in. Now, I get that they're not horribly relevant to whether this defendant committed this crime. Okay, because there's no identifying stuff. They said there was a man in the house that night. That's basically the extent of the identifying information. So I don't think it's horribly relevant, but they get it in because 911 calls almost always come in.
Dwayne, you raise a good point. There's another motion that the defense has where they are objecting to this identification from one of the eyewitnesses to a man with bushy eyebrows. And they're objecting to that descriptor of bushy eyebrows because it was used by police to look at the license plate picture of Bryan Kohberger, determine if perhaps he could be their suspect, even though they didn't have a lot at the time to go on. But your thoughts on if they'll be successful in trying to keep that identification out, which is more specific than
it's
a man
strange
being
Dylan had a whole lot of
inside
pictures on her wall with bushy eyebrows.
Yeah, that probably comes in. I mean, it is relevant, okay, and it's what a witness saw, okay, and generally speaking, if what a witness saw is relevant to the case, then it usually comes in. Now, it's not an identification of Bryan Kohberger. It's an identification of bushy eyebrows, which thousands and thousands of people have. And
so subjective identification
one component of identifying the defendant.
Another defense motion is to exclude the penalty because Bryan Kohberger apparently has been at some point in his life, or maybe now, has been diagnosed with a form of autism, saying that he, because of his condition, should be exempt from the penalty.
This is a good explanation to a lot of this.
State of Idaho. Is that on some level an admission here, or
no, it's not.
I mean, I get that the motion isn't a straight admission, but What's your take on that motion, and do you think it'll be successful?
That's that's important, because in order to do the penalty, it's got to meet certain criteria. And if you're below a certain IQ level, you have certain mental defects, there's a lot of things that go into deciding whether or not the penalty is appropriate. Yep. And in a case like this, where there is a penalty, where they're alleging the penalty, the defense attorneys are obligated to file every possible motion they can. And if they don't, that could be seen as ineffective assistance of counsel.
100%.
I'd be surprised if he hasn't been evaluated by a forensic psychologist.
He has.
Or psychiatrist.
The defense isn't pulling any of this out of thin air.
Autism, where he's at on the spectrum, and all that. And I think that's going to be important for a judge to consider whether or not to leave the death penalty on the table.
That's a really big question as we march ahead to this August 2025 trial date. I have another motion to ask you about, Dwayne, and I do want to point out, we've been digging through these newly unsealed motions because there's so many that have come out at once. Before, there were many that were filed under seal, and actually the judge admonished both parties, saying everything can't be filed under seal. It can't all be secretive. So that's why perhaps we are seeing more that has already been filed. But there's one, again, about the penalty where the defense wants to preclude it because the state has violated some discovery deadlines. They haven't disclosed what they needed to with regards to experts, and they're citing the Lori Vallow case in Idaho, saying that's why the death penalty got...
Real quick, did everybody see that Dateline video of Lori Vallow? Holy cannoli. I mean, she's got more than one egg short of a dozen going on upstairs, if you know what I'm talking about. The statement she made absolutely blew my mind. If you haven't seen that interview, go watch that interview. It is absolutely some of the most wild stuff I've ever seen.
Pulled from her case because the state didn't meet certain disclosure deadlines, and rather than prejudice her, they marched forward to the trial without the penalty. Do you think that could be a strong argument, especially with that precedent there in Idaho?
Well, absolutely. Every state has their own set of rules about what has to happen in a penalty case, and there are specific separate rules for penalty cases, and a violation of those rules can take the penalty off the table. Mm-hmm. And if there's precedent for something that really recent, where the penalty was pulled for a violation of the same rule,
100%,
then that's pretty powerful for the judge.
The team, obviously, their goal, it seems, their major goal is to get him off of
Absolutely.
Potentially they seem to be targeting a lot of their motions, especially as this has gone through, towards that goal. It is a very high bar, and it should be.
Obviously.
To sentence somebody to. But if you're going to conjure up a version of an event that might constitute the penalty, I think a lot of people would argue that this is
it. And let's talk about that for just a second. It is an insanely high bar to go first degree DP. That is the highest and hardest standard to prove in a court of law. I understand the state's narrative. 4 individuals were brutally attacked. It wasn't warranted by an individual who had no idea who they were. He came in and absolutely destroyed those individuals. So this man deserves the DP. The family was pushing for the DP. The general public was pushing for the DP. And yes, on the story alone, this does seem to, at least to a degree, fit a lot of that criteria. I mean, if Bryan committed this crime, he would be among the worst in the state of Idaho. The problem here and the concern for me is this. In the scenario Bryan committed this crime, does the state have enough evidence to meet that bar? Because in that scenario where they don't have enough evidence to meet that bar, that would mean then that Bryan walks. And I'm not aware of Bryan being charged with any lesser included in this particular crime, meaning some sort of lesser passing charge. I mean, you cannot convict a guy on a story alone. You have to have the evidence to back it up. Who can tell the better story? Individuals saying this is open and shut are 100% incorrect. You're putting a whole lot of faith in a man called Bill Thompson, who doesn't have a whole lot of experience arguing these types of cases. Now, I'm not saying that they can't prove this. We know that they have evidence. We just don't know how strong that evidence is. And we have seen numerous holes in the story as we know it. The probable cause affidavit is trash. These recent unsealed documents 100% prove the probable cause affidavit is a lie. Dylan was not asleep. She wasn't in a frozen shock phase. She didn't go back to bed. Her and her roommate were aware. Stop putting all your faith in this probable cause affidavit. Stop putting all your faith in what the state is claiming to say they have. We don't know what they have, and we've heard these stories before where the state says they have all this overwhelming evidence towards this one suspect, and then when it goes to trial, they have nothing. The best position to be in right now is flexible. They may have what they claim to have, they may not. The defense may have stuff to refute what the state says. Stop saying they won't, and don't say that they're going to make it all up. The defense team cannot completely fabricate exculpatory evidence out of thin air. There's two sides to this story, and we don't know which one is true. There are certainly issues with the story as we know it.
For very, completely helpless victims, she murdered allegedly a deranged stranger. What's your overall take on the strength of the case from what we know now?
If they have the evidence, they might be swinging for the fences and missing.
Well, you never know what's going to happen at a trial. But with regard to all these motions about the penalty, once they put the penalty on the table, it is mandatory that these attorneys file every possible motion they can to get off the death penalty. It's not discretionary. If there's even a scintilla of evidence for a motion, you got to file it. I mean, you 100%. Just have to, because being a penalty case, this case will be scrutinized for years and years and years by dozens and dozens of lawyers, and so they've got to do it. Now, with regard to the strength of the evidence, I mean, it's a pretty decent circumstantial case. The DNA evidence, I'm understanding there's some unknown people in the DNA, and there's mixtures, which gets really complicated. And that's a DNA expert's.
That's the concerning words. He said it seems to be a pretty decent circumstantial case. He didn't say this was a strong case. He didn't say this was open and shut. It's decent enough to convict an individual on first degree with the DP in that particular state. That's the big question and concern I was just talking about. I'm not necessarily convinced they have enough to meet this bar. That's just my take. I've pointed out numerous holes and problems in multiple videos with what the state is saying in terms of their story about Bryan and these four individuals. First degree is a high bar. They're going to swing for the fences. There's a chance they may strike out. And if they strike out, they only get one bite at the apple.
Job is explaining these when there's mixed DNA and how well you can tell,
problems.
Who's who and who did what, and and juries generally kind of glaze over with the really technical stuff, and if they get an expert that says, "Hey, I looked at the DNA and it says that he did it," they're going to believe that. All the technical stuff, why that may not be true, is hard to get through to a jury.
Yeah, and one of the reasons likely that they changed the venue in this case because of all the publicity there in Latah County. Dwayne, thanks so much for that analysis. We'll, of course, continue to follow what is happening in the Kohberger case with our Kelly Craft throughout the day.
So here we are. We're hanging anything and everything on transfer DNA. We know there's holes in the story. The defense has pointed out holes in the story, and the state hasn't really been able to combat those holes very well. A lot of us said there's no way the roommates didn't know. That was validated. And a lot of us said there's going to be something within that 911 call that doesn't make sense. We don't have an explanation for the actual delay in calling 911. But I'm more curious to hear about your thoughts with this particular video. Let me know down in the comments below. And if you enjoyed this and a more fair, open conversation, maybe check one of these videos out. Y'all be safe now.